Well, greetings. I'm not sure anyone's here. I see audit them, but nobody else. It's kind of strange. Well, I guess I'll play one more song and then we'll. Oh, we got shockproof. Right, getting some people in here. I'm gonna play one more song, I guess. Try to get some people in here. Goodness, I was expecting a few other people for this one here because we're gonna go over some actual drafting of complaints, and I thought it might be important. But give me a moment here. Let me just get some of my sound. Yeah, there we go. That should sound better now. That thing always changes. All right, so we get that set. Let's try a different song. And try this here. Another song. Okay, here we go. Wow, nobody's finding out about this. We'll do one more song. Jeez. Okay, everyone. Greetings. Looks like we're finally getting some people here, and we can start the show. All right. Let's get to it. Let's see here. Get a few things set up here. What's going on here? Okay, so we're going to be going over enforcing federal rights against states and state officials. And in this one, we're going to be going over drafting the complaint. So let's get right to it. And let me see if I should probably zoom in a little bit more here. And see how it looks on the screen. Looks pretty good. Okay, so this was updated in 2015. So, as we did in the first episode of the federal complaints, we had the scope of litigation in Chapter 1 of the manual. So we went through this: legal theories, relief requests in advance, the core theory of litigation. So while the attorney's the Esquire's pre-litigation memo and later trial notebook may serve as her personal strategic guide, the complaint serves as the litigation map that will determine the route the parties take as they navigate pretrial motions, which we'll go over today, discovery, also settlement, and trial, if necessary. It will also serve as the first public face of litigation. You understand? Your complaint will be the first public face of the litigation, describing the case to the parties, the media, the judge, the clerks, and the opposing counsel, and will set the tone for future discussion and communication about the case. Very important things to take note of here. And I want to bring attention to the fact that setting the tone for the future discussion and communication about the case is crucial to making sure that you can come to an amicable conclusion for the case at hand. Whether that requires, monetary settlement or other kinds of remedies, whichever it may be. Just really quick, I want to mention that I do not know anything about law, legal, lawful, anything, so nothing you hear tonight should be taken or construed as advice in any way, given, shape, form of legal, lawful, or otherwise. This is strictly for educational, entertainment purposes and not to be used for any type of practice or other types of applications in real life use. Don't try this at home. All right, we got Archangel for Truth here. All right, so everyone's coming in. Beautiful. Okay, so we're getting right to it here. So what we're looking at here is the whole purpose of this complaint. And the complaint's a litigation map. It's the first public face of litigation. And it will also set the tone for future discussion. So 3 important points you want to notice about your complaint. Because if the complaint sets the wrong tone, it's going to really make it difficult for further discussion and communication. Right? You always want to have the public on your side. So it's important to make sure that the complaint, for the public-facing aspect of it, is something that people will want to be on your side about, because obviously it would be something that's in the interest of the people. So the complaint has to serve as a way of communicating that effectively to the public. And it will also serve as the litigation map, meaning it will help you decide what motions you need to do, what types of remedies you're seeking. So all this will be contained in the complaint, okay? And, a personal strategic guide, all these kinds of things that they will be using in addition. But that complaint is the central component to the whole case. So let's continue here. While the complaint's role within a strategic framework remains as true as ever, 2 recent Supreme Court cases, Bell Atlantic versus Twombly and Ashcroft versus Iqbal, require the legal aid attorney accustomed to liberal notice pleading to rethink her approach to complaint drafting. They keep saying her as the just a general pronoun here instead of his or her. They're just saying her. So that's what they're doing in this document here. Welcome to the politically correct world of manuals. All right, let's continue here. So it's still a manual. Shouldn't it be a she-ule? All right. Require the legal aid attorney accustomed to liberal notice pleading to rethink the approach to complaint drafting. So let's consider this. There's a Supreme Court case, 2 of them, and these 2 will have entirely reinterpreted the federal rule of Civil Procedure 8. Wow. And impose a heightened pleading standard requiring that allegations of unlawful conduct be plausible rather than merely possible. Wow. Twombly and Iqbal have spawned an enormous volume of academic commentary and case law. Wow. As well as bills in Congress to restore prior notions of notice pleading. Every legal aid attorney must become familiar with Twombly and Iqbal and their circuit's evolving interpretations of the new plausibility standard instead of probability. When drafting complaints, attorneys must anticipate motions for dismiss for failure to meet this standard. For failure for wow, that's a tongue. Attorneys must anticipate motions for dismiss for failure to meet this standard. Okay. I'm not sure if that's a typo or just legalese. Prior to drafting the complaint, the advocate must conduct a reasonable investigation under the circumstances. We turn first to a complex aspect of that investigation, contacting employees of the prospective adversary. So the prospective adversary is the state or state officials, right? Pre-negotiation, pre-mediation, pre-litigation. We're going to be going over the pre-litigation right now. And before we do that, oh, wow, so I have your thing on the screen here. There we go. So we're going over the first part here, the pre-litigation, actually. So let's do this. The pre-filing investigation may include client interviews, interviews of witnesses. So, all right, so again, this is a perspective of legal aid. So imagine this is for the Esquire that's tasked maybe, it could be for ACLU or it could be for anything. You've got a federal rights violation here, and you're making a complaint against a state or state official. And you have pro bono, let's say, Esquires working for you. And they're going to have paralegals and legal aids and all these other assistants helping them along that do really most of the work, the filing and all the procedural duties. Therefore, this is a manual for that particular segment of that legal community. And the reason we're going over this is because if you decide not to use that legal community, these are the procedures that are already pretty much in place in the courts, and whether you actually use them or not, it would behoove you to know them, because I could almost guarantee you'll find benefit in all of these, one place or another, for practically any kind of case you're doing involving complaints and federal actions. Again, we're going to get back to this right here, but I just wanted to throw that in there. Again, that's just my opinion. And of course, it has absolutely no legal foundation basis whatsoever, and definitely don't try that at home. Okay, so we have the pre-filing investigation. The pre-filing, see this? Before filing the case, investigation may include client interviews. This is before we filed. That's the person complaining, by the way. Interviews of witnesses. Review of public and other records. Audit them. Correspondence with opposing parties. Correspondence with opposing parties. Maybe from public records. And request for information pursuant to public records or Freedom of Information Act provisions. Excellent. Yep. So I like to call this stuff, when we're pulling a review of public records, the correspondences within those government organizations, which are also public records, and the request for information pursuant to public records or Freedom of Information Act provisions, which would include those. I like to also call that not just pre-litigation investigation, but just even sometimes a pre-discovery is a good term when you're utilizing these Freedom of Information Acts and public records. When possible, use pre-litigation investigation rather than formal discovery to establish facts. Now, when possible, because you can't always get those records that you need to establish the facts, but if you can with public records, then it's best to do that right off the bat, because that's going to be much easier to obtain, and you won't have to actually file the case to obtain them, which you would have to do if you're using a formal discovery. You can't do a formal discovery until you've actually done your filing. Even when the investigation requires the cooperation of adverse parties, the cooperation is more likely to be forthcoming before the suit is filed. So then we're getting into the pre-proper notices. So these are all pre-file act investigations, we call them. So we haven't filed anything yet. You haven't filed a complaint yet, but you're going to do a little bit of investigatory work just to make sure. And then we can look at these, what are these, pre-proper notices. I don't know if they even do proper notices. All right, let's continue on here. A thorough investigation. So yeah, a thorough investigation would often benefit from interviewing current or former employees of a potentially adverse corporate entity or government agency. Rule 4.2 of the American Bar Association Model Rules of Professional Conduct governs the permissibility of ex parte contacts with represented persons by channeling most communications through counsel. Rule 4.2 specifies, all right guys, the ex parte. Does anyone remember what ex parte is? So I think that's when someone's absent, but geez. Kind of embarrassing, but we're going to have to pull out Black's Law until someone in the chat tells us what it is. I'm really bad with my Latin lately. Why isn't it going the right one? Oh. Almost there. Okay. All right, we get Deanna in the house. Okay, so let's do this here. Where'd it go? Ex parte, there it is. 17th century. We can zoom in a little more for you guys. '17th century, done or made at the instance and for the benefit of one party only, and without notice to or argument by any person adversely interested. Of or relating to court action taken by one party without notice to the other, usually for temporary or emergency relief. An ex parte hearing. Ex parte injunction. Despite the traditional one-sidedness of ex parte matters, some courts now require notice to the opposition before what they call an ex parte hearing, sometimes spelled ex parte. Okay, so communication. Okay, there it is. So when we're talking about Rule 4.2 of the American Bar Association Model Rules of Professional Conduct governs the permissibility of ex parte contacts with represented persons by channeling most communications through counsel. Oh, wow. That's interesting there. So what does that mean? Specifies when representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter unless the lawyer has a consent of the other lawyer or is authorized to do so by law or court order. Okay, yeah. The primary concern behind Rule 4.2 proscription is to avoid overreaching caused by disparity in legal knowledge. It is designed to protect lay parties. A violation of your... Okay, so we see here, this is just a represented people. No contact. So, okay, so that's only for esquires. Now that we could skip over this rule here. Again, unless you're a member of the bar, that doesn't apply. But let's see what they say here, though. Ex parte. So, one, if the constituent is regularly working with the organization's attorney with respect to the matter being litigated. Constituent. If the person is authorized to obligate the organization regarding the matter, or 3, if the person's act or omission with respect to the matter may be imputed for purposes of liability to the organization. All right, so enough with the American Bar Association stuff. So this is for, again, if you're a legal aid, you need to follow these rules because this is your duty. So this is about, okay, let's get down to the purpose of complaint. Sorry about that little digression there, but again, this is written for the practicing esquire, so you're going to have some of that interwoven in with the important things we need about procedure and the actual process of drafting these complaints. So let's do this. Purpose of the complaint. Complaint has at least 5 purposes. We're from 3 to 5 now. So to commence litigation, to tell a persuasive story to a varied audience, that's your public-facing end, right? To sufficiently set forth the jurisdictional, factual, and legal basis of the case to avoid or limit the possibility of a motion to dismiss. Interesting there, huh? Limit the possibility of a motion to dismiss. 4, to enhance the usefulness of the defendant's answer to the complaint and the ability to obtain useful information through formal and informal discovery. And 5, to lay the groundwork for the resolution of the case through settlement. So let's stand back for a second and look at this purposes of the complaint. Let's see. Gucci. Who's Gucci? Oh, I don't think I have all my chat showing up here. That's what's going on. I hear everyone. There we go. Oh, okay. So who we got in here? Who's Gucci? Paul had the last 2 broadcasts. Sly could hook us up, tell us what that is. Oh, Sam's. You have rights is here too? I'm not seeing anyone. All right, well, let's continue, guys. Again, the issue with this thing here is a lot of the stuff is written for the Esquire, but these are things that we still need to know. So let's get right down to the nitty-gritty here. I just want to give you my opinion on some of this. Of course, it is to commence litigation. We want to tell a persuasive story to a varied audience, although I'm not too crazy about a persuasive story. You know, you want to make a clear story, I believe, because it should be persuasive in the facts. Oh. I got it. That makes sense. Okay. Yeah. Okay, yeah. You have rights, cops have duties. I was hoping that he was going to show up on this because I was kind of doing this in a way for him too, because this applies, but he'll be able to see the rebroadcast. So, but I was really hoping to get him on here. Okay, let's continue. All right, to sufficiently set forth the jurisdictional, factual, and legal basis of the case to avoid or limit the possibility of a motion to dismiss. I'd say that's not the real reason why, but it is an important reason. But you want to be able to sufficiently set forth these just because that's part of law. All right, to enhance the usefulness of the defendant's answer to the scene. Now, this is kind of through the formal and informal discovery. Persuasive versus persuasive. Is persuasive even in Black's Law? I wonder. We can find out. So, nope. Okay. Just want to check and see. All right. Let's get back to this puppy. Okay. Yeah, it does. Well, the interesting thing is the thing about the English language is it's full of these ambiguities, and it makes it very easy to do, the deceit, the word trickery, the witchcraft, the word spells, because of the ambiguities within the English language. There's so many there that because the phonetics, the way it's written, the way when people process what the written word is, do they speak it in their head and they see SEW? Do they say so? When they see SOW, do they say sow? When they see COW, it's cow. But when they see, anyways, it goes on with the English language has so many of those ambiguities to it that lend itself to a particular auditory, I guess you'd say just the ambiguities that allow you to embed messages in different layers so you can communicate in different ways with the same statement based on the ambiguities in the language and the way it's constructed. So English lends itself very well to that. So on the flip side of that you could easily misinterpret words based on that too, because even our prefixes and suffixes are sometimes, some are Greek, some are Latin, so it can be confusing too when you start to break it apart, unless you know really about the entire etymology of the word and its roots and how it came into the English language, because it is a modern language. But that being said, I don't like to dwell too much on those things there, but I do like to dig deep into the historical and cultural context of words, and that way we know that we're using them properly in the right place. So using an appropriate level of precision for the words means a lot more than trying to break them down into a reductionist mess. All right. Again, the resolution of the case through settlement may or may not be the main goal of the complaint, but it typically is part of it. But if you're an Esquire, that's all you care about, because as we said here by Sly, it's all about the Benjamins. Oh, Deborah, I'm glad you're in here. You haven't missed much. We're just getting started. We're just the purpose of the complaint, so you haven't missed much. We went through the fluff where this is written for the practicing Esquire or the legal aid, so that they're going to be dealing with, the substance of the issue here, but in the procedural way. So if you're going to do this stuff yourself, then it behooves you to learn everything you can about how this is going to be moved through the court system, and then you could use the applicable parts of this to customize your complaint, and you prepare the proper map for your litigation and set the groundwork for your communications of a successful case, hopefully. Okay, let's continue on here. So, commencing the litigation. A civil action commences upon the filing of the complaint with the court clerk. Bam. The filing date of the complaint ordinarily determines whether the lawsuit is within the applicable statute of limitations. Bam. Another important point. The date of filing It also sets the clock running for other dates, such as the deadline for serving the defendant with the summons and complaint. The date of the service then triggers the timing of a series of pretrial procedures. You get that? So let's walk through this again. Let's say that we done with our pre-discovery. Again, we're talking about before here that you have the pre-discovery that you would do prior. Let's get over here. The pre-litigation investigation, right? Before the filing, the pre-filing investigation. And we're going to do Freedom of Information Act, whatever provisions we have available for that. We're going to take public records, any kind of information we can that's publicly available before filing. And when possible, use pre-litigation investigation rather than formal discovery to establish facts. Now, you can't always do this, but if you can, that's much better because, again, you can't do formal discovery until you've filed. And if you could have the facts established in your filing based on public records, it's going to make it a lot easier to litigate that case in your favor. So thorough investigation would often benefit from interviewing current, so it gives a list here, current former employees of the adverse corporate entity or government agency, and then we get into the ex parte stuff with the bar. Because they don't want you talking to the wrong people. See, what they're doing here, they're scaring the shit out of the legal aid so that they don't go out and start asking the right questions to the right people and keeps them pigeonholed in their little spot there to pump out paperwork. Again, my opinions here are not to be construed as anything else. All right, what we got here? Wait, how can a complaint go to court without all investigations to even make a claim? I don't know. I mean, I guess you just have to figure out a way to get standing in whatever jurisdiction you're in. Not too sure. There might be some elements that can get the case started, and then others will be brought forth after you've done your discovery. Again, remember, they're all allegations until the trial. So let's get back to commencing our litigation. Pre-complaint. Yeah, well, it's pre-claim. I mean, your complaint is kind of the claim in a way, right? So it's, I don't think there would be much of a difference. It's before you do any filings with the clerk is what we're talking about here, is to do those things prior to doing your filing so that when you do your filing, you have as many established facts contained in your initial filings as possible. I think that's the goal of what we're trying to do here. So yeah, good question now. Let's get back to commencing litigation now. So a civil action commences upon the filing of the complaint. So previously we were talking about all the pre-investigation we could do. And if we've done all that, now we're ready to file a complaint. If we couldn't come to a solution now, remember we were interviewing employees and et cetera, et cetera. The filing date of the complaint ordinarily determines whether it's in the applicable statute of limitations, sets a clock running for other dates, there's a deadline for serving a summons and complaint. Date of service then triggers a timing of a series of pretrial procedures. So, yeah, it's all show. Absolutely. Okay, so when to file the complaint is a decision to be made based on factors beyond the need to meet the statute of limitations. Of course, if your client is facing an irreparable injury, you will need to file the complaint promptly, along with or immediately followed by a motion for temporary and preliminary relief. If immediate harm is unlikely, the legal aid esquire may need to balance the client's interest in a prompt resolution of the matter with the risk that the quick filing of a complaint may actually prolong the case in the long run. Interesting thing there, huh? So let's think here. If immediate harm is unlikely, esquire needs to balance the client's interest in a prompt resolution of the matter. Okay, why? Because they're going to say, well, if we do a quick filing before all our investigations are complete, the complaint may actually prolong the case in the long run. Important things to think about. But again, if you're doing your pre-trial discovery, like I said, it's I call it the pre-discovery. that would give you an advantage as far as getting the case to move through the court quicker because there's less facts to establish as the case runs on. While complaints can be amended fairly liberally, doing so takes time and may ultimately delay the resolution of the case. Often, the best approach is to spend the time needed initially to file a polished and thorough complaint. Now, that's probably the best line of this whole thing here so far in this section. Often, the best approach, pay attention, spend the time needed initially to file a polished and thorough complaint, because we need to learn how to write effective complaints to get results. Okay. You must also bear in mind that litigation is like a chess match. While the complaint is your first move, you must have subsequent moves in mind. Such tactics include filing a prompt motion for class certification. Right. A motion for summary judgment, on cases involving little or no discovery. Or, see now, you could do this if you have established your facts with public records in pre-discovery, because then you little or no discovery. That means that they either have to rebut those facts or they're going to stand. And that means you can get a summary judgment, meaning you're not going to have to go through lengthy trials. Or pressing for a prompt initial conference in discovery. Once you have contemplated your subsequent moves, re-examine your complaint to make sure it adequately supports these strategies. These strategies may call upon you to begin drafting additional documents before the complaint is filed. So again, this is your roadmap, your litigation map of where you're going to go. So that being said, you're going to know what to prepare beforehand. Telling the story. Okay. Shockproof, I don't think even lawyer, attorney, I've never seen even those in the Constitution either. I've seen counsel. Esquire is a catch-all term, and none of these are titles of nobility here in America. We just a title. It's a obligatory title. But yeah, it's not really code words, just what we call them. The complaint is the first opportunity that an esquire has to tell the client's story and to explain why the lawsuit has been filed. Audit them is listening in the background, is what he says. He's going to be listening in the background, and he may be on, keywords maybe, later. Barristers now, over there in Britain, and esquire I think is like a junior knight or something. I'm not, but here they're typically with the, hey, we got to audit them in there. That's what they are. The attorneys, they're the esquires. But esquire works better because I don't want to use, when do you say lawyer? When do you say attorney? I can always say esquire and be right. Okay. It is the first document that will be seen by the judge and law clerks and will be referred to them repeatedly throughout the case. The complaint may also have an audience in the clients, the defendants, opposing counsel, the public, the media, and other observers. Let's take a step back here for a second and think about this now. Let's think of it in the context of many of the people we see on YouTube here, in YouTube land, our valued corporate partner that's providing us with this remarkable platform with such the far-reaching audience, unmatched in human history. Please stop shadow banning this stream, YouTube. Okay, let's think about the people that are in here in this YouTube land and when they have to do complaints. And think about this complaint, right? It's the first document that will be seen by the judge and law clerks, right? And it'll be referred to them repeatedly throughout the case. Repeatedly. It's going to be a first impression, and it's going to be repeatedly seen. This is like the first impression that can't go away. The complaint may also have an audience, of course, in the clients. Like your clients. Oh my gosh. Well, this is you. You're going to have an audience in yourself, because we're talking about if you're doing this yourself. The defendants, they're your audience, right? The opposing counsel, that's the defendant's esquires. See, that's why I don't like to use the other terms, because esquire works for this. All of them. The public. The complaint has an audience in the public, has an audience in the media, and in other observers. But this media is what gets me, is because it has an audience in YouTube. Your complaint may, keyword may, also have an audience in YouTube. The complaint must therefore be logically and narratively compelling, so that when the reader or the viewer reaches the final page, he feels that a wrong has been committed, that your legal claims are sound, and that the relief you are requesting is reasonable and deserving. In addition, the complaint is your first opportunity to present yourself. We'll leave it at that. Thus, you want it to be error-free, well-written, persuasive, and reliable. Yeah, well, I'm seeing if the viewer count goes up when I give in a few good words for the our valued corporate partner. All right. So, the best place to give a clear and concise summary or core theory. What's a concise theory? A core theory of your client, of your story. I'm going to leave out this stuff here with stuff like this, clients and the attorney for the plaintiffs and such, because we're trying to look at this in the context of the people doing the people's work and not having interlopers doing it for us. And in that way, we kind of are looking at the basic game plan. These are the day-to-day tried and tested manual for getting things done in this arena. So we're learning it just as well or better than the ones you would normally seek to represent you. So when you go to make your presentment, your opportunity for a presentment, like to present yourself sounds kind of redundant. Why don't we just say, in addition, the complaint is your first opportunity to make a presentment. Thus, you want it to be error-free, well-written, persuasive, and reliable. The best place to give a clear and concise summary or core theory of your story is in the complaint's preliminary statement. It is the legal soundbite that introduces the more technical and complex matters that follow and what the judge and others rely most upon in understanding what your case is about. Okay, we get that part too. Hey, we get LA Spike in the house. Yeah, they will be very selective in the esquires they hire. But I think you're better off to fire the esquire instead of hire them. All right. Especially with those in the tribes there. They're not even their own people. It should be focused and written in plain language. So the legal soundbite is when you have the actual technical and complex matters that follow. And it's an introduction to them in a way that people can read it in what they say here, plain language. As if nothing else in this complaint should be in plain language, I guess. The summary is going to be in plain language. Drafting the preliminary statement is truly an art. because although it is neither an argument nor a detailed rehashing of the contents of the complaint, it must be convincing. So I kind of differ with this opinion here. I wouldn't say it's an art. It's definitely a skill, and it could be a craft of wordsmithing. However, if it goes beyond that, art in the hands of a villain is black magic. You don't want to have people focusing on it as an art of persuasion rather than to seek the truth and bring remedy where people have been wronged. The balance of the complaint continues to tell the story of the case. See, a complaint needs to be persuasive. A complaint needs to be factual, it seems. Clear and factual is the essence of it, and I think they mentioned it here. The best approach to spend the time needed to initially file a polished and thorough complaint. So, we're talking about polished and thorough. And, the old saying goes, you can't polish a turd. So if it's full of shit, you're not going to make it polished. The facts section is the primary place where the story is fleshed out. Beautiful. As in an affidavit, each paragraph of the factual allegations should set out a simple, objective statement of fact. Every fact that is necessary to plausibly support each of the legal claims and the standing of the plaintiffs to advance them must be included. So, again, this is something that's going to be enumerated so that could be rebutted one by one by the opposing party. It should allege with some precision which legal requirements have been violated, what defendants have done or failed to do, and what relief is sought. So, bam, allege with some precision. Well, let's just be precise. Which legal requirements have been violated? That should be very precise. What defendants have done or failed to do. Now, that's, of course, going to have some precision to it. And what relief is sought, which we would like it to be precise to. You should cross-check the complaint against your litigation and trial plan. And, as you draft the complaint, have an understanding of how each fact alleged will be proved. Thus, as both a matter of style and strategy, you should generally avoid prefacing allegations with, upon information and belief. See this here? So, can you really polish a petrified turd, though? Well, it's no longer a turd if it's petrified. Now it's mineral. I think you have the organic matter left there. And bullshit's definitely organic. All right. If, however, an allegation lacks evidentiary support, but is likely to have evidentiary support after a reasonable opportunity for further investigation or discovery, it must be specifically identified in the complaint. So we can see where this gets likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. So that's a much better one than upon information and belief. It must be specifically identified in the complaint. So you need to specifically identify likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. So they give it to you in quotes. Doesn't have to be, but that's a pretty good example, I believe. All right, let's continue here. Once the factual portion of the story is told, the sections on legal claims and relief should flow as logical extensions of the facts, bringing the reader along with you. We call them crocolytes when they're petrified. Yeah, I've heard of those before, but I've never seen them. No. All right, let's see here. So what they're trying to tell you here is that a good idea, and I'll tell you, it's an outline. If you have an outline form, the factual portion of the story told with outline form, meaning it's enumerated with the major points, on legal claims and release should follow as logical extensions. That's breaking down your outline from your Roman numeral 1, 2, and 3, and each of those are subsections A, B, and C, right? This should flow as logical extensions of the facts, bringing the reader along with you. Ooh, storytelling. Well, narratives are always important for communication. However, in this case here, they're speaking with both ends of their mouth because, one side of it, we got to do everything with legalese, saying this little part can be in plain English, but everything else is going to be in this legalese, yet they want to bring the reader along with you. I mean, it's asking a lot, especially in the factual portion. So, again, take this all with a grain of salt, and remember, this is geared towards the legal aid, which is below an esquire, which is below the judge, which is, these are the grunts. But again, when you do your own work like this, you're doing your own legal documents, it's, this is just the stuff you have to do. Again, never-ending story of enslavement, yeah, but when you look at it this way, that when you learn to do this yourself, it's not enslavement just as much as when you have to pick up a rock to move it because you want it there, or if you need to go carry a bucket of water up to your place because you need a drink. It's not really enslavement. It may be to nature, to the natural laws. But again, when you get someone else doing it for you, well, now it's kind of who's in slavery now? Is it the person you hired is a slave to you, or are you tricked into slavery because you think you're getting the upper hand? So yeah, there's some issues in here. All right, I'm glad you agree, so we can continue on. Again, these are things I believe it's important to know about this process, because even if you weren't doing it, you can make sure it's being done right. So not everybody has the resources to do this themselves. I understand. And one thing I really appreciate everyone that's here and spending their time learning this tonight and to be here, because it really shows that you really have an interest in this, and that I believe that me spending time doing this is going to leave everybody with something they can go out and use in actions to improve their life or to avoid any of these bad incidences from happening when our rights are violated by our own public servants. All right, let's look, cross-check. So let's cross-check the complaint against your litigation trial plan. And as you draft the complaint, have an understanding of how each fact alleged will be proved. That's important right here, because each fact alleged will have to be proved. Thus, as both a matter of style and strategy, you should generally avoid prefacing allegations with the upon information belief. However, if an allegation lacks evidentiary support but is likely to have evidentiary support after a reasonable opportunity for further investigation or discovery, you must specifically identify it in the complaint. Once the factual portion of the story is told, the sections on legal claims and release should flow as logical extensions, like I said, an outline of the facts, bringing the reader along with you. When drafting, never merely copy allegations from another complaint. Why would a legal aid, which are your slaves there, the legal slaves, why would they ever copy allegations from another complaint? Don't they care so much about their profession? They would never do something like that. Why would you even have to say this? Without clearly understanding whether those allegations are appropriate in the case and verifying that the allegations comport with current law in your district or court. So they're not telling them not to do it, just to be very sure that they're going to apply. But yeah, definitely go and do it. All right, let's see what we got going on here. Oh, great. I'm glad you are. So we're going to get some more to go on here. So we're going to continue. And I believe I can give you the link to this too, because this is a public document. I'm going to look in and see where I got it from. It should be in here somewhere. But let's finish this up, and then I'll post it in the chat or later on, so people will be able to find it. So style and strategy. What competition are we in? Yeah, I know that's an interesting thing there. So let's see. Style or strategy. So let's see. Ask colleagues in your office to review the complaint as a double check for factual clarity and legal sufficiency. Well, we'll ask our colleagues and our friends that we like to co-create with, and we can always review it. We're always happy to do that. Protection against motion to dismiss. So, of course, this is the first thing they're going to do is a flurry of motions against your complaint. So the complaint must be sufficient to survive a motion to dismiss. Your thorough review of the law in the substantive area involved should reveal to you the typical grounds for motions to dismiss and the potential weaknesses in your case. Substantive area. Your thorough review of the law in the substantive area involved. So substantive, I know we've looked at this before, but this makes this should be overlooked what they're saying here. And let me just pull this up because wow. Almost there. Oh, wow. There we go. 1994. Okay, give me a second here. Right. We go substantive. Oh boy. So what was the word we were looking at? Substantive what? Substantive area. All right, substantiate, to establish the existence or truth of a fact. All right, so by competent evidence to verify. Substantiate. So substantive area, though, I'm trying to figure out what that means. Substantive felony. Yeah, well, substantive law, the part of law that, because it said substantive law, didn't it? Yeah, okay, so the part of the law that creates, defines, and regulates the rights, duties, and powers of parties. Oh, as opposed to procedural law. So, far as the administration of justice is concerned with the application of remedies to violated rights, we may say that the substantive law defines the remedy and the right, while the law of procedure defines the modes and the conditions of the application of the one to the other. You get that? Yeah, please hit the like, everybody. So substantive law is what we're getting at here. Oh yeah, Archangel for Truth. Yeah, good. I hope that. I think that should be the. I think that's it should be a new trend. All right, let me see here what we're. So your thorough review of the law in the substantive area involved. So the substantive law. See, they just don't want to say it, I guess. Remember, this is written for Esquire. It's not written for us. But it's the same procedure that we would have to follow. So by understanding the procedure, we're going to be able to do it better, because no one's going to do it better for you than you. The part of the law that creates, defines, and regulates the rights, duties, and powers of parties, as opposed to procedural law. So you have substantive law. So they have to know the substantive law in this area. So the administration of justice is concerned with the application of remedies to violated rights. So far as the administration of justice is concerned with the application of remedies to violated rights, we may say that the substantive law defines the remedy and the right. You get that? So your remedy and the right violated will be determined in substantive law, while the law of procedure defines the modes and conditions of the application of the substantive law to the procedure, right? Or the application of one to the other. Remedies of violation rights defines the modes that the remedies are applied to the violated rights. I get it. Man, that old 1947 language. So that makes sense. That the procedure only defines the way the remedies are awarded for the rights violated, but the rights themselves are defined by the substantive law, and so are the remedies. All procedures got to do is define how they're applied and the ways in which they're applied. Does that make sense? If it does, I hope so, because this is an important word for your complaint, because it was a part of the law that creates, defines, and regulates the rights, governs the rights, duties, and powers of parties. So there's substantive law that we've looked at. We're looking at the American jurisprudence on public officials, right, and employees. So there's certain rights and duties and powers that are defined by the law. And these procedural things are only ways that we go about applying them. The remedies to the rights, defining the rights, defining the remedies, and then the procedures will define how we apply them. Okay, let's continue here. So the complaint must be sufficient to survive motion to dismiss. Your thorough review of the law in the substantive area involved should reveal to you the typical grounds for motions to dismiss and the potential weakness in your case. It is helpful to imagine yourself as the associate in the opposing counsel's firm or office assigned to draft a motion to dismiss your case, thus providing yourself with an opportunity to identify and address your complaint's weaknesses before you file it. Now, that's good advice to do there, of course. Hey, we got Disciple of the Messiah in here now. Tremendous. Yeah, we're getting into the good stuff here. Oh, boy. Prior to 2007, the Legal Aid Esquire could take comfort in the notion that all the rules require is a short and plain statement of the claim, and that will give the defendant fair notice of what the plaintiff's claim is and the ground upon which it rests. For 50 years, the court followed the principle set forth in Conley v. Gibson that complaints that supplied such notice should not be dismissed unless it is beyond doubt that the plaintiff can prove no set of facts in support of his claim, which would entitle him to relief. Supreme Court rejected efforts to impose heightened pleading standards as recently as 2002. See, the court held that a plaintiff pleading Title VII and age discrimination and Employment Act claims was not required to plead each element of a prima facie case of discrimination. Okay, noting that the McDonnell-Douglas standard was an evidentiary, not a pleading requirement, the court held that the complaint need only give fair notice on the basis for the plaintiff's claim. So, let's see, prior it could take comfort. So I'm trying to see how the plaintiff's pleading was not required. Trying to understand why they're even saying about taking comfort. All right, well, Esquire talk. Let's continue here. The Tubley, a 2007 Sherman Act case is antitrust. The court made it quite clear that the complaint must do more than merely provide notice to the defendant, right? Rather, it held that a complaint must contain facts that plausibly suggest a conspiratorial agreement rather than facts simply alleging conduct consistent with such an agreement. Bearing the traditional Conley formulation, the court cautioned that a plaintiff's obligation to provide the grounds of his entitlement to relief requires more than labels and conclusions, and a formulaic recitation of the elements of a cause of action will not do. The complaint must do more than simply leave open a possibility that the plaintiff could prove its case. Instead, the pleading must contain detail sufficient to create a reasonable expectation that discovery will surface evidence of wrongdoing. The court insisted that it was not imposing a heightened pleading standard, but instead required allegations of sufficient detail to cross a line from conceivable to plausible. The court's clear repudiation of the Conley, no set of facts, language, and extended discussion of the cost of discovery underscore a more rigorous pleading standard. Man. And the court's 2009 decision in Iqbal took plausibility pleading beyond antitrust cases and imposed it quite rigorously. Iqbal was a Bivens case brought by a Pakistani arrested after 9/11 and housed in a maximum security prison under allegedly harsh conditions. To prevail, Iqbal had to plead and prove that the defendants at issue, the former Attorney General and the FBI Director, had adopted or approved of detention policies for the purpose of discriminating against him on the basis of religion, race, or national origin. Of course. The court explained that the pleading standard does not require detailed factual allegations, but it demands more than an unadorned. The defendant unlawfully harmed me accusation. Yeah, I've heard this case too. Now, what we're saying here is the defendant unlawfully harmed me accusation. Okay, it demands more than that. It wants detailed factual allegations, not the defendant unlawfully harmed me accusation. Yeah, the deprivations of rights for federal court. Disciple of the Messiah is right here. We belong in equity jurisdiction courts using special matters sealed for the judge. So the equity jurisdiction is going to be, the remedy is going to be, something where you could either have a court order for, to cease an action or to take action. And it could be that, if they harmed you or whatever, then, it could be something to correct that from it happening in the future and such. But then there are ways to get monetary reliefs that we looked in the first section of this too. So again, what they're stating in section 1, or the part 1, I should say, of the expose we did on this document, they mentioned about the monetary damages and the ways to make sure the pleadings were constructed correctly so that you could be awarded them in certain situations, because in others they won't be applicable. And off the top of my head, I don't recall, but I know they're in there because I remember coming to the realization of that in that section of this document. So that's a very helpful part to review too, if you wish to find out about that. And the let's see here, what else we got here. The 1983 is the federal, isn't it? I believe. Oh, I'm cutting out. Hang on. You know what? Let me hold on 1 second. I'm just give it 30 seconds. I'm gonna let it. I know I figured out a way to get this to stop buffering. Give me about 30 seconds and just hang in there. I'll be right there. Let me get something on the screen here for you to read. Here, we'll get to the next section here. Okay. And I'll give a couple seconds here. 30 seconds. Okay. Should be back. We back. Okay, I think we're back. And the stream looks stable. All right. So let's get back to where you just left off, in case you didn't hear me. All right, so court explained that in the pleading standard Rule 8, analysis does not require a detailed factual allegations, but it demands more than an unadorned, the defendant unlawfully harmed me accusation. So we need detailed facts, not just he unlawfully harmed me. And with respect to the plausibility standard, has facial plausibility when the plaintiff pleads factual content that allows a court to draw the reasonable inference that the defendant is liable for the misconduct alleged. So there it is. The Iqbal court noted that the plausibility standard is not akin to a probability requirement, but it asks for more than a sheer possibility that the defendant has acted unlawfully, where a complaint pleads facts that are merely inconsistent or merely consistent with a defendant's liability. It stops short of a line between possibility and plausibility of entitlement to relief. That's what you get when they screw up. Iqbal's significance lies in operationalizing the plausibility standard. Jeez. The court in Twombly acknowledged that a court must treat the complaint's factual allegations as true, even if doubtful in fact. But in Iqbal, the court cautioned that the courts need not accept as true threadbare recitals of the elements of a cause of action, supported by mere conclusory statements. Such recitals are regarded as legal conclusions not subject to the presumption of truth. The court set out a procedure for separating legal conclusions from factual allegations. All right, here it is. A court considering a motion to dismiss can choose to begin by identifying pleadings that, because there are no more than conclusions, are not entitled to the assumption of truth. So do you understand the difference, right? Conclusions are not the same as truths. While legal conclusions can provide a framework of a complaint, they must be supported by factual allegations. When there are well-pleaded factual allegations, a court should assume their veracity and then determine whether they plausibly give rise to an entitlement to relief. Okay, I hope that's making sense for everyone. And am I coming through nice and clear now? I hope so. This procedure requires the court to engage in a two-step analysis that seems to go beyond what was required in Twombly. First, the court should identify which statements in the complaint or counterclaim are factual allegations and which are legal conclusions. Factual allegations versus legal conclusions, guys. Legal conclusions should not be assumed to be true and may essentially be discarded for purposes of the second step, assessing the factual assertions. The words are muddy? Damn. All right, let me see if I can fix something here real quick. Don't waste too much time. Lower the compression ratio, maybe. Check. Is that better? Let me know if this is better here. Oh, okay. All right, then we'll leave that there then. Let's see here. Let me catch up here. I'm clear? Okay, good. Oh, you meant confused. All right. I'm a little, keep an eye on how the stream's coming across because I'm not having anyone monitor what I'm doing here. Okay, good. Can you do a claim session right after this complaint session? Complaint versus claim. I have to look more into that because you're going to have You're making your claim, but it's in the form of a complaint because you're making a claim against someone that harmed you. So in this case, it's a complaint, but I think they are used kind of interchangeably in this, legally. But in this case, I believe it's referred to as a complaint because of the nature of the claims you're making. They're claims of damages that were caused, and you're seeking a remedy. So it's, but I mean, it is a claim. You're the, I'm not too sure on that one, but I would stick with just keeping this as complaint in the language that they're using here because that's going to be consistent. Right, a complaint is a form of claim. And in this context, I believe keeping it consistent with complaint is just going to make it easier. But there's a big difference. I think that a claim is a bigger category and a complaint is a subset of claims. But we could figure this out because I don't want to dwell on opinions. So we can get right here to Black's Law and we'll find out here. So we're going to look up claim. So, boy, it's in here a lot, you know. Problem is that every result, and there's a whole lot of results, it's the number of result you're on doesn't tell you where you are in the alphabet. Claim, come on, H. Claim, is it? Claim, nope. Still not there. Yeah, here we go. Claim. It's like 309. There it is. Okay, so let's look at claim first. All right. Interact with it over there. Okay, there's claim. Okay, 13th century. Well, here's the first definition. The aggregate of operative facts giving rise to a right enforceable by a court. The plaintiff's short, plain statement about the crash established the claim. Also termed claim for relief, 1808. 2. The assertion of an existing right, any right, to payment or to an equitable remedy, right, we're talking about here, even if contingent or provisional. Spouse's claim to half of the lottery winnings. 3. A demand for money, property, or a legal remedy to which one asserts a right, especially the part of a complaint in a civil action specifying what relief the plaintiff asks for. So, stand corrected. It's the part of a complaint in a civil action. So, no, a claim is part of the complaint in a civil action specifying what relief the plaintiff asked for. So it's a portion of the complaint. See, definition 3, it's a demand for money, property, or a legal remedy to which one asserts a right, especially the part of a complaint in a civil action, which this is, specifying what relief the plaintiff asks for. So there it is. So the claim in this context is the part of our complaint specifying what relief we're asking for. And it doesn't mean something in another area, because look at all these claims. We got claims, involuntary gap claim, and priority claim, and unliquidated claim, and stale claim, matured claim, colorable claim. I mean, there's so many claims. Frivolous claim. So these are all things to know. But yeah, the aggregate of operating facts. This is the 13th century original definition, giving rise to a right enforceable by a court. So that claim is a portion of your complaint. So we might get to that part too in here. But thanks for this. I really appreciate that attention to that detail, because I just learned something there. I thought it was the other way around. But the claim is the part of the complaint that you're going to ask for your remedy. the relief. All right, cycle of themes. Cool. All right. Let's move along here. Okay, so let's just finish this section up here. All right, so legal conclusions should not be assumed to be true and may essentially be discarded for purposes of the second step, asserting the factual assertions. Assessing the factual assertions. I'm sorry. Those assertions are not evaluated in overall context, but stripped away from the discarded legal conclusions. Determining whether a complaint states, oh gosh, if we'd only read on, huh? Determining whether a complaint states a plausible claim for relief will be a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. All right. Take a look at what we're doing. Okay, yeah, all right. We're going to check that link out. Good for 7 days. Cool. All right. Is it showing up on the screen there? There we go. I can't bring that on the screen, but you guys can all see the Archangel for Truth has a link in there for a disciple. And let's see here. Okay. Yeah, let's throw that link there. No, you have to have a reason for your claim. So the complaint establishes. Remember, it's there's that the substantive law has to be addressed in the complaint, and then that's going to justify your claim. So that's why you need both parts of it. But it would be nice. However, we got to give the defendant their chance to rebut it too. It's just part of the deal. All right. So I can't wait to check that link out. So let's hurry up and finish this part here. Okay, so now we figured out determining whether a complaint states a plausible claim for relief will be a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. Oh, good Lord. The court regarded the complaint's allegations in Iqbal as conclusory because, in context, the court discerned a more likely explanation for the detentions. Iqbal was rounded up as an undocumented alien because of his possible connections to the perpetrators of 9/11 as part of their terrorism investigation, rather than because of discriminatory animus. All right, let's see here. Complaint establishes a wrongdoing and asks for remedy in the claim. Right, that's what we read in the definitions there. And what they just stated here, they've just restated what we read in Black's Law, is that the claim is the part of the complaint that specifies the relief sought. Yes, so you are correct. All right, cool. All right, Disciple, we get that there too. Nice. All right. Okay, so let's finish up this section here. And the plausibility principle may have had particular impact in Twombly and Iqbal given the nature of the claims asserted in those cases. In Twombly, there was no direct evidence of collusive behavior in violation of the antitrust law. Rather, the plaintiff's alleged scenario consistent with such behavior when, at the same time, there existed another equally or more plausible explanation for the apparent lack of competition, that was entirely innocent in nature, without factual allegations underlying an inference that the defendant's behavior was collusive. The plaintiffs fell short of offering allegations that made their theory a plausible one in light of the alternative. Similarly, in Iqbal, the court suggests that there was no direct evidence of unlawful discriminatory intent. That intent must be inferred from other facts. The facts alleged by the plaintiffs, the court believed, were equally or more consistent with an explanation that the defendants acted without discriminatory intent. In short, no facts were alleged to bring the inferential gap between the behavior and the intent or motive for that behavior. See, this is a very important nexus to be aware of here is no facts were alleged to bring the inferential, the educated guess, the legal theory, the gap between their behavior and the intent or the motive for the behavior. Just because they do a bad behavior isn't enough. Intent. Law is about intent. The Twombly-Iqbal standard may be particularly problematic in cases in which the defendant is the custodian of most of the facts underlying the complaint or cases turning on mental states of intent or motive. It is difficult to discern how to allege unlawful intent or purpose without using language like knowingly, willfully, that is not conclusory in nature. Without discovery, plaintiffs will have considerable difficulty unearthing support for such allegations. But such allegations will not permit the plaintiff to proceed to discovery. Iqbal also pretends a significant expansion in judicial power and discretion, rather than merely determining whether a complaint was sufficiently detailed to afford the defendant notice. A fairly objective inquiry, the federal judge must now use their judicial experience and common sense to determine whether allegations are more subjectively plausible. In a sense, plausibility is in the eye of the beholder. The fudge sometimes may find challenges to the behavior of governments or corporations implausible because the allegations do not conform with intuitive or expected understandings. Oh my gosh. For the legal aid Esquire, Twombly and Iqbal have significant consequences. They call for more detailed and fact-specific complaints, which in turn may require more rigorous pre-filing investigation and preparation. Lurking below the surface of Twombly and Iqbal are Rule 11 implications. How certain must the legal aid Esquire be of the more detailed factual allegations required to satisfy the plausibility standard? The judge drawn to hear the case may have an immediate impact on the chances that the defendant will file a motion to dismiss and prevail on that motion. An increased possibility of a motion to dismiss may alter settlement dynamics. You lose your leveraging. For new legal services Esquires, close consultation with senior staff at Esquires is necessary to navigate through these more difficult and uncertain waters. Now, would you want to hire one of these people that have to go run into their senior staff? Okay, it's, again, this stuff here is, I get there's settlement dynamics, and, geez, okay. Anyways, we can continue from here. Enhancing usefulness of the answer and discovery, because this is going to be the part where after we've gone through the decision to draft the complaint and we're going to file the case, and that's why we will have discovery, because you can't do the discovery until you file the case. And yes, Shockproof, you caught that, huh? And what was the other word? Competition? Anyhow, yeah, so that's an important thing to consider here. They like these analogies. The analogies here are rather insipid when you really think about it. I mean, come on. Close consultation with senior staff Esquires is necessary to navigate through these more difficult and uncertain. More than what? So this is terribly written. But there are pieces in here that you have to know. I guess I'm a little spoiled from reading the American jurisprudence because it's written almost like poetry. It's inspiring and enlightening, and you have a feeling of a legacy of free thinking people that preceded us. So it's a nice feeling when I read that. When I'm reading this, it's irritating. and things like even when we were reading the compiled statutes, that was a little dry and very, overly legalese sounding. I don't mind using specific words when they are necessary, but it seems like the language was being used, words like thereat and thereof and therefore and, things that are not thereat. Who uses thereat? So that being said, I like the American jurisprudence. We got to get back into that. I have some great volumes on that. Maybe I'll do a poll and see which subjects people want to do next that I can focus on, because I have a whole lot of them. And I could just go on the things I'm interested in that I know a lot of people are too, but there's probably some things in there that really might resonate with a large audience. Blackstone, Harry Blackstone, yeah, but I'm trying to remember now what I read of his. But that's an interesting thing to, let's see if I have any of his books. If that's who I'm thinking of. Equitable Remedies. Yeah, okay, yeah, let me see what I got. That might be a good one to do too. I like stuff like this because this stuff here it wears me out. I'm doing this really because I believe it's stuff that we need to know how to do, because remember, there's the substantive law and the procedural law. And we know the substantive law. I think we understand when our rights have been violated. We know, and we can articulate that. The problem is it gets the procedural law part of it. And we have to be willing to take the mental struggle to learn this too. It's not that hard. And our ancestors had much more difficulties to deal with also, and worse tyranny. So I don't believe it's asking too much for the people to just do a little of learning, so they don't need to be reliant upon esquires that really don't have their best interests in mind. They have the interest of the Franklins. It's commonly called a license to steal, and that's why they do it. But that's just what I've heard, and it's an opinion. I also heard that from law school, that the A students, when they graduate, end up working for the B students, and the C students end up being judges. So take that as you will, and I think that will, if we keep this up, that we'll have an advantage in both knowledge and skill in navigating these troubling waters, what do they call them? Uncertain and difficult waters. I love the wiggle room, and yeah, they got some pretty great words they like to use in here. Insipid, to say the least. But on that note, let's see what else we got here in the chat. Conditional acceptance. It's conditional acceptance. What part of law is that in? I'm trying to think what conditional acceptance is. Is it in contract law? Let's see, you got a jury trial on February 23rd, Deborah, huh? Yeah, we get a we got to definitely get this going on here. That's kind of like, it's all contracts, shockproof. Yeah, okay. Yeah, we got to get definitely which one is for Deborah? Let's see, shockproof, conditional acceptance. Okay, yeah, all right, then we will. Then I'll find out. I'll see what I have on it. If I can, I will, and I'll do that next. Again, I wanted to get this part done here too, because I know this is something that You Have Rights, Cops Have Duties was interested in doing, and I think this will help Deborah too. So I wanted to go over this, and we're going to continue on this too, because we have some more to go for the settlements and such, and we're going to see how far we are on this. We're halfway through this document easily. So one more session, we'll be done with it. And then by that time we're done with it, the thing we'll all be able to leave with is a clear knowledge of not just maybe how to do this ourselves, but to know what to expect if someone was doing it for us, to make sure it was done properly and properly polished and full of facts. And I think this helps just in general, whenever we're writing complaints, to be able to effectively express ourselves in well-written complaints is always going to benefit us in the end. So the more practice we have doing it, the better we get at doing it, and the easier it'll be. Yeah. Okay. Yeah, I'll get you an email you can send to me. I don't know if I should put it up here. Yeah, I haven't been on to the on these Discord servers here, other than for actually just for software development. I haven't really been on for any of the conversation stuff, but I'll try and check that out too, because it might be a better way to communicate with you guys. And again, what I do here is just it's for entertainment, educational purposes. It's not to be construed as advice or recommendations in any way, shape, or form, as I have no legal knowledge or advice to give anyone. And what we're doing here is just reading through this document here, this manual for legal aids, just because it's interesting and it's salient for some people. And I just want to have a good content for the audience out there. Again, I really appreciate you guys spending the time here and to go over this. And I know that if you're spending the time here to do this, the few people that are in here, I understand it's not a big audience, but I really do appreciate that the interest that you all have in here to stick through and go through this, because then it really encourages me to continue these up and to try to get this knowledge out as much as possible. Again, it's helping me as well. And I hope if we could all co-create with this type of knowledge together, it's going to really help preserve the freedoms that we've enjoyed in our life for posterity too. So on that note, I'd like to thank everyone for coming along for the ride. Hey, we got all of them still there. All right, great. Yes, we are all family here, and we're going to help each other out. So again, knowledge is power, but only when it's applied. Otherwise, it's just latent. So these are where the rubber meets the road here, where we're going to be able to draft complaints and to be able to actually get some action happening in our favor without relying on esquires that may not have our best interest in mind. So, all right, on that being said, we got LA Spike. Yep, we got to sub to all these people. Thanks, Archangel, because it's hard for me to type all that stuff in while I'm doing this here too. And let's see what else we got here. Yeah, so Deborah, I think you need to join the Discord service. They have a, yeah, this is all entertainment here, guys. All entertainment. So I think you just need to sign into the Discord server, and that'll get you hooked up. Once you get in there, then you can have free communications between each other, and it's uncensored and I guess unmoderated, whatever. There are some also alternatives for private communications, and I have a lot of these solutions too that we can use for different things. Everything from video calls to texting, audio, and essentially it's peer-to-peer, so we have no intermeddlers in there listening in or anything like that beyond the direct internet connection between us. So as long as the basic security stuff's in place there, I mean, short of state actors, there's no way you're going to get eavesdropped or anything like that. It's very robust technology that's out these days and is available to everyone. In fact, I was thinking tomorrow, since it's Sunday and I do have some time, I was thinking about doing a mind-blowing live stream on artificial intelligence. There's been some incredible breakthroughs in the last couple weeks, in the last couple days, that I don't think most people have any idea what's around the corner. And the things that we're talking about here, and like this document writing stuff and writing motions, I mean, if anyone's going to be thinking that their job's on the line, it's going to be the esquires. They're going to be useless in 5 years. Watch. Now, I'll prove it to you tomorrow if you want. In fact, maybe once we get on this Discord thing, I'll be able to show you some pretty cool things you can do. Yeah, when I get off of here, I'll figure out. I got to get a quarantine browser and everything to go on the Discord there, and you got to practice safe information. But here's the thing: is that what I've found is that a lot of the technology and stuff today it's a lot easier than it used to be to access. And I think that working together and not relying on the big companies to provide us with the tools we need would allow us to actually do a lot more than waiting for them to give us the next great piece of technology. I mean, it's sitting there waiting for us, really, if people only knew. I did one about non-rocket space flight. To think that we're sending rockets or satellites up with Chinese fireworks is ridiculous. I mean, that's the biggest dog and pony show I've ever seen. This CERN. You know how many of these stupid particle accelerators they have built all over the country and all over the world? These are just, money sinks of tax dollars going into, deadbeat scientists that can't get private grants. So a lot of the things that we're led to believe are so great and all-knowing are not. And if we take back our power through knowledge and applied knowledge, and I think it will turn the table back to the people's favor, and the pendulum can once again swing in the direction of personal liberties. On that note, I don't want to dwell any further. I want to thank you all for coming again, and I will see you all on the next one.